Good morning, everyone. My name's Terence Lynch. My function is to introduce you to Thew and Lucas Shipway, and I'd like to begin by thanking you all for getting up in the dark and coming to the free advertisement of our collective skills and knowledge, and we thank you for that. Penny's been a barrister since 2005, a lawyer since 2000. Lucas has been a barrister since 2009 and a lawyer since 1999. You should have a paper like that and some statutory notes, and there are slides that have been prepared which you do not have but are available if you speak to Shani McPhee, who's standing up and walking towards us as I speak. The other reason I'm here, I think, is to demonstrate our commitment to diversity. You'll have noticed that both Penny and Lucas are tall, and I am not. You'll have noticed that they are on the thin side, and I am not. A practical demonstration of the Chamber's commitment to diversity. Lucas will speak first. He'll talk about the practical steps before commencing proceedings, and then the legislative scheme for the recovery of assets from debtors, including bankrupts. And I'd ask Lucas to start.
Thank you very much, Terry, and may I repeat Terry's thanks to you for joining us this morning. As Terry said, I'm going to be talking about some practical steps to think about before commencing proceedings, where what you have in mind is seeking to freeze assets or otherwise enforce the status quo, I suppose, with a view to enforcing a remedy, some relief in favour of your client, or perhaps, I suppose, being on the other side, being the recipient of such steps. I'm going to be talking about a couple of tools in the kit bag: freezing orders, caveats, and preliminary discovery. There's others, but they're the ones we wanted to talk about this morning. And then I'll quickly give you an outline of the legislative scheme, and specifically Section 37 A of the Conveyancing Act and Section 121 of the Bankruptcy Act, which are extracts you have in printed form in front of you, I hope. Then Penny, as Terry said, will take over and talk about some of the arguments that debtors can be expected to raise, some recent decisions that Penny was involved in which have helpful implications where you are seeking to freeze and recover assets, and then she'll talk about recovery orders and costs, and we'll make some concluding points at the end. As I said, I'm speaking about freezing orders, caveats, and preliminary discovery. Freezing orders are also known as Mariva injunctions, asset preservation orders, just in case the language is not familiar to you. The court is empowered to make a freezing order under the Supreme Court rules, and we're talking today about the Supreme Court, I should indicate, with or without notice to the respondent, to prevent the frustration or inhibition of the court's process by seeking to meet a danger that a judgment or prospective judgment of the court will be wholly or partly unsatisfied. The rules are in Part 25, Rule 11 of the Uniform Civil Procedure Rules. The power is concerned with money claims as distinct from proprietary claims. That's an important distinction. If the court's got no jurisdiction to give a relevant money claim or a money judgment, then it has no power to make a freezing order under those rules. Now, that was considered by the Court of Appeal in a planning and environment case, Newcastle City Council and Cavistock in 2008. Now, freezing orders are often or perhaps typically sought ex parte. That means that the other party is not put on notice in the first instance of the application, Now that's for obvious reasons. If you tell the rogues on the other side of what you're planning to do, they may well move before you can. And so the idea is that you go before the court without notice to them and say, here is the reason why we should be granted these orders. And you invite the court to make those orders, but generally on a temporary basis, and then the other side has an opportunity, once they are notified of the orders and the orders are put into effect, to approach the court and have them lifted if the basis on which you put forward they say is not appropriate. Now that carries with it obviously some important conditions. It's necessary to be candid with the court, and we'll come back to that. It's also an exceptional remedy, and the court won't grant it lightly, ex parte or not, frankly, but where it's an ex parte application, then that's particularly important because the courts, as you'll appreciate, depend on having both sides before them arguing the point in a contentious manner, and if that's not happening, then the court is naturally nervous that it's getting the full picture. There are some prerequisites that are generally necessary. You need to have a judgment in your favour, ideally, or satisfy the court that you have a good arguable case on an accrued or a prospective cause of action. These things are dealt with in Rule 25.14. You need to prove, and so I'll come back to the question of a prospective versus an established cause of action. If you have a judgment and you can say this judgment ought to be satisfied against this asset, then you can perhaps, and there's a risk of that asset being dissipated, that makes it easier. Typically, though, what you're doing is saying, we think we have a cause of action and here's why, and here are the assets and here's why there's a risk of dissipation of them. It's a bit more difficult where you don't yet have the judgment. The danger of dissipation is very important. You need to satisfy the court that there is a danger that the judgment or prospective judgment will be wholly or partly unsatisfied because the judgment debtor, the prospective judgment debtor, or another person might abscond, or the assets of the debtor or other person might be removed from wherever they are, or might be disposed of or dealt with or diminished in value. Sometimes the order will be sought against the third party, so the judgment debtor themselves is not the owner of the asset, say, and so therefore there's an application in respect of the assets of a third party. In that case, it's necessary to prove there's a danger that the judgment will be wholly or partly unsatisfied because the third party holds or is using or is exercising a power of disposition over assets of the judgment debtor or prospective judgment debtor. The third party is in possession of or in a position of control or influence concerning the assets of the debtor, or there is ultimately or may be ultimately available to the applicant as a result of a judgment, a process whereby the third party may be obliged to disgorge assets. And so tracing, for example, would be a means by which you'd establish that the assets which are in the hands of the third party are amenable to the court's jurisdiction and ought to be the subject of an order for relief, and in that situation you may be able to get a freezing order against the third party. You need to address the discretionary elements, and there's no closed list of what those elements are. The courts will have regard to things like the impact on innocent third parties, the conduct of the applicant, and there may be other factors depending on the circumstances. The orders themselves that you put forward or ask the court to make need to be carefully crafted. They obviously need to catch the assets that you have in mind in a way that doesn't allow the rogue to exploit some loophole. They also need to have suitable carve-outs in them to allow the other side to, or the subject of the order, to deal with the assets for living, legal and business expenses in the ordinary day-to-day conduct of their lives. The courts won't impose an order which has the effect of preventing people from feeding themselves, for example. And so you need to think about that. There are some precedents out there which seek to address those matters, but that has to be looked at carefully. It's also obviously important to think about the duration of the order. I indicated where it's an ex parte application, it may be made on a temporary basis first to allow the other party to come before the court and put its case. But even on a different basis, you still need to think about how long the order should be in place for, and there will be usually liberty to apply so that the party that's some prejudice or some change of circumstances permits them to approach the court to change the orders. You'll need to provide an undertaking as to damages, obviously. That's important in this area and can be significant. It's a matter that may require careful advice because the implications of the order can be significant, and the damages that flow from the order being made in an appropriate way can be significant. And I said that on an ex parte application particularly, it's necessary to give full disclosure of all material facts. The court needs to be comfortable that it understands the circumstances in which it's intervening. The prerequisite that the applicant has a judgment or a good arguable case on an accrued or prospective cause of action is obviously critical. A good arguable case has been described as one which is more than barely capable of serious argument, and yet not necessarily one which the judge believes would have a better than 50% chance of success. That's from an English case, the Nynemia. It's a less stringent test than requiring proof on the balance of probabilities. Chief Justice Gleeson, in the Patterson case in 1989 in New South Wales, endorsed what had been said by the trial judge, Justice Giles, where the trial judge talked about the way in which sort of inferences might be drawn about whether or not there's a good arguable case. And he said this: if a defendant has only the matrimonial home, then the court would very likely require strong evidence of an intention to dispose of the home and decamp. Where, however, it is not known what assets are held or where, but the scheme from which, according to the prima facie case, assets have in all probability been gained was one of some ingenuity and involved overseas connections, the inference is readily available that the participants in the scheme will not stand by whilst the court proceedings cause them to account to the plaintiff out of their property. So I suppose that points to the fact that in some circumstances, if you can present evidence to the court of a Byzantine scheme by the other side, which has the whiff, if you like, of a scheme aimed at avoiding creditors, then that may be enough to get you there. Obviously, the flip side of that is sometimes people's financial affairs are complex, and there's nothing suspicious about that at all. It's just how they've chosen to arrange their affairs. So it's a question of balancing that. But you need to satisfy the court that there is a good arguable case that there is a risk of dissipation of the assets. The balance of probabilities, as I say, is not the test. That might be the test at a final judgment, but it's not the test for the purposes of obtaining a freezing order. That bar is seen as being set too high. Rules 25.14 Subrule 4 and Subrule 5 set out some of these requirements, and so it's important to have a careful look at those. And I indicated that sometimes we are seeking to obtain an order against a third party, and obviously the difficulty there may be in gathering sufficient evidence to present to the case to the court about that party's role or the assets that party holds. We'll come back to preliminary discovery, which may be of use in that context. Finally, I wanted to flag a helpful quote from a decision in 1979 in the UK. It's a little sexist, but the language was that there must be facts from which a prudent, sensible commercial man can properly infer a danger of default. That is, I think, a helpful way of putting it. Is in some ways it's like the prudent bystander test. Would a prudent person, understanding the facts as presented to the court, infer a danger of default? If you can put forward a prima facie case of fraudulent misappropriation of assets or serious wrongdoing, that will readily support the inference that the respondent would not preserve its assets. But mere assertions that the defendant is likely to put assets beyond the plaintiff's reach will not be enough. Turning then to caveats. Caveats, as you know, are a means of preventing or restricting dealings with land. They can be framed in a variety of ways, but typically they are a general caveat preventing a dealing with land, and they are registered. The Real Property Act, section 74, capital F, subsection 1, permits a person who claims a legal or equitable estate or interest in land to lodge a caveat. The lodging of the caveat is done by completing a form and submitting it to New South Wales Land Registry Services, as they are now known. It's effective from the time of lodgement. This is an aspect of the Torrens system, of course, which is a system which relies on the registry and the register, and now increasingly is an electronic system. A caveat may be lodged by any person, including the registered proprietor, who claims an interest or interest in Torrens title land. A notice of caveat, which is Form 10-0220, is prepared and sent to all registered proprietors affected by the caveat. So again, in terms of notice, the caveat can be lodged and will take effect, but when that happens, the owner will be notified forthwith. If the registered owner objects to the caveat, he or she will file a lapsing notice. The caveator then has 21 days to obtain an order from the Supreme Court extending the caveat. That's done under UCPR Rule 25.2. In order to grant such an extension, the court must be satisfied that the claim has or may have substance, and that's in 74 capital K of the Real Property Act. What is a caveatable interest? Well, it's again not possible to define a closed category or closed list of caveatable interests. Constructive trusts have been held to give rise to a caveatable interest, and I've given you a couple of cases on the slides which explore or set out the principles that govern that rule. Justice Brereton explained the situation as follows in 2008 in Sutherland and Vale. It's well established that on an application for an order extending the operation of a caveat, a test substantially the same as that for an interlocutory injunction applies. First, the applicant must demonstrate that the caveat has or may have substance. The phrase may have substance encompassing the concept of a seriously arguable case. Secondly, the court will have regard to considerations of the balance of convenience and prejudice, and finally to other discretionary considerations. So that menu of considerations is probably reasonably familiar to you. That's really the menu that applies where an interlocutory injunction of any kind is being sought. As I said before, in the context of freezing orders, discretionary considerations come into play. Conduct of the applicant will be relevant. But critically, what you're seeking to do is satisfy the court that there is again, an arguable case which is furthered or protected by the caveat. The other side might argue that the constructive trust sought is remedial only, and so there's no present equitable interest in the property. That argument has been run a number of times, but it seems not to be good law. Justice Dean in Mushinsky and Dodds in 1985 said what's on the screen, that the old maxim that equity regards as done that which ought to be done is as applicable to enforce equitable obligations as it is to create them. And so, if you like, the law looks forwards and says, well, we, on the facts here, are prepared to accept that you can make this claim out. On that basis, we'll enforce or extend the caveat. Tracing may also provide the necessary basis. Won't talk about tracing in depth today, but in simple terms, it's the procedure by which to identify property wrongly transferred because of theft, breach of trust or mistake. For example, defences to tracing are possible, of course, and particularly where the property has been transferred to an innocent third party without anything having been given to the defendant in return that the plaintiff can claim in lieu. And Penny's going to be talking, I think, a bit more about those sorts of defences and the sorts of points that debtors might make in response to these sorts of applications. Finally, I want to talk about the tool of preliminary discovery. Now, generally, discovery, as you know, is available only after proceedings have been commenced and pleadings have closed. Indeed, in the commercial and technology and construction lists, it's not generally available until after evidence has been put on. However, the rules do permit discovery before proceedings have been commenced in certain circumstances. Under UCPR Part 5, preliminary discovery is available to ascertain the identity or whereabouts of a potential defendant or defendants, obtain documents from a prospective defendant to decide whether to sue, and to obtain documents from a third party. Now, the plain advantage is that preliminary discovery can avoid wasted costs pursuing the wrong defendant, both your own costs and, of course, the costs of the defendant, probably, because you'll be ordered to pay them. But also, it potentially prevents assets being dissipated, apropos of the theme today, because it avoids a pointless proceeding against the wrong person. If you're pursuing the wrong person, then the right person may well be absconding with the assets. So it can be useful to allow you to target the right person. Now, of course, it puts the recipient on notice of a possible intention to sue. So it doesn't have the stealth, perhaps, of some of the other remedies we've been talking about. A party is entitled to seek material on preliminary discovery that will assist it to determine whether or not to commence proceedings. Now, this is a relatively low bar. There's no need to show a prima facie case against that person in order to obtain orders for preliminary discovery against them. In O'Connor and O'Connor in 2018, the Court of Appeal said this: it may be emphasised that there is no requirement that an applicant establish even a prima facie case for relief, nor is it necessary that an applicant specify with precision the cause of action proposed, although it will be necessary in order to make it appear to the court the applicant may be entitled to make a claim for relief, which is the words of the rule, that the applicant provides some particularisation of the nature of the relief in contemplation. That is so not only to enable the court to form a view about whether the applicant may be entitled to make a claim for relief, but also to enable the prospective defendant, if an order is made, to determine which, if any, documents in possession are to be discovered. So the usual fishing expedition type defence that you might see in a discovery application otherwise is not necessarily available to a defendant. That you can, as an applicant, legitimately say, well, I'm making some investigations here, I'm not sure whether to sue. It may be that you're not sure whether to sue the person who you are targeting at the moment, but it may also be a wider question as to whether you think, an investigation as to whether or not you in fact have the cause of action at all. Caveats can be maintained pending discovery. There's a couple of cases that deal with that. So those two things may work in tandem. You may get the caveat first and then pursue preliminary discovery. And the all else being equal, the caveat should be held in place while that process is pursued. Turning then briefly to the legislative scheme, about which Penny will say a lot more than I, but a creditor can commence proceedings, including along with a bankruptcy trustee, to access assets of a debtor under two principal provisions, 37 capital A of the Conveyancing Act or section 121 of the Bankruptcy Act. What's the difference? 37 capital A is applicable to individuals and companies, whereas 121 is applicable only to individuals. Now, there are also provisions in the Corporations Act, but they're beyond the scope of what we're going to talk about today. We're really focusing on these two provisions predominantly. 37 capital A you have in front of you, and you're probably familiar with it, but the effect of it is to make voidable any transactions where the debtor has alienated, that is, disposed of, assets with the intent to defraud creditors. The focus of the section is on the debtor's intent to defraud, and that's a question of fact. This means that proceedings under section 37 capital A require a demonstration of the transferor's intent and also the transferee's knowledge of that intent, and these are based primarily on evidence. There are fewer elements to establish in order to rely on this provision compared to section 121. 121 provides that a transfer of property by a person who later becomes a bankrupt, the transferor, to another person, the transferee, is void in certain circumstances. And those circumstances are set out in the section. And so the 121 is a creature, I suppose, of the insolvency law. It's a mechanism by which transactions can be unwound, and Penny will talk about some of the nuances of that, particularly having regard to the cases that she's been involved in. The trustee in bankruptcy plays a very important role, obviously, under the Bankruptcy Act, whereas section 37 capital A is a remedial provision that, again, permits the unwinding of transactions but doesn't really fit quite into that insolvency regime. Is available. Instead, it's available to applicants to use with a little bit more freedom, I think it's fair to say. Now, just as a point to note in terms of procedure before I hand over to Penny, using section 121, if there's a deregistered company involved, you're seeking to join a deregistered company, then it's necessary, obviously, to obtain court orders to reinstate the company as a first step, and that's done under section 601 capital AH of the Corporations Act. That's the point at which I will hand over to Penny.
Thank you very much, Lucas. Thank you very much, everybody, for coming this morning. So, as Lucas said, I will talk with you this morning about the powerful implications of Section 37 capital A of the Conveyancing Act and also Section 121 of the Bankruptcy Act. You should have before you a copy of 4 separate legislative provisions, one of which is Section 37A, one of which is Section 121, and then there's another 2 sections of the Bankruptcy Act, Section 58 and Section 116, and I'll talk about those as well. They all work together and they all operate to help creditors recover or get access to assets where, as Lucas was saying, where you have a judgment debt and you have evidence that, you have a judgment debt and the debtor has failed to pay the judgment debt, and you have evidence that the debtor has been dissipating assets to evade creditors, essentially. And you have an article in front of you as well, and the article is simply a short description of the proceedings, or of certain proceedings, some of which are in these slides, They were all related proceedings. They went over a number of years, and they commenced with an enforceable judgment debt. It was a judgment obtained in the Supreme Court. It doesn't really matter where it's obtained, but as soon as it's an enforceable judgment debt and you have a debtor who is dissipating assets, then you can commence proceedings. So, of course, once the debtor, you would take steps to bankrupt the debtor first, and once the debtor is bankrupted, the bankruptcy trustee is appointed. The bankruptcy trustee does not necessarily play a very proactive role in the proceedings, but joins with you as an applicant if you're in the federal court. Joins with you as an applicant, and then your client's going to run the case, you're going to run the case. The bankruptcy trustee stands beside you, and the powers under the Bankruptcy Act at the end of the proceedings, once you've demonstrated that you can actually unwind the dissipation of the assets and shares, once you've achieved that at the end of the decision, that's when the powers that vest in the bankruptcy trustee come into play, because then you get orders that everything, all of the shares in all of the companies and all of the assets held by all of those companies then simply vest in the bankruptcy trustee, and that's what we'll have a look at. And we'll have a look at the arguments that the central debtor and each of the colleagues, if you like, associates, friends of the central debtor, all of whom will be joined to the proceedings, the arguments that they can all put up to defend against what they're, in addition to the actual statutory defences, but the arguments that they can put up to defend against the creditor's claims. So that's what we'll have a look at. So having commenced proceedings, so you would get leave to commence to proceed against a bankrupt. Often a debtor will simply not object to that, but you get leave from the court to commence proceedings against a bankrupt. All of this would be as part of perhaps a preliminary application for freezing orders. You would have done your searches to start with, your ASIC searches to find out all of the shares that the debtor happens to own in all of the companies that the debtor happens to own. So perhaps the debtor has 4 or 5 companies, the purpose of which was to hold any number of assets. You'd do property searches to find out how many assets each of the companies held, and continue to do the property searches reasonably regularly, so that as they get moved out of the reach or out of the hold of the company, you know where they've gone and you can move quickly, because you need to move quickly to stop things from simply disappearing. And I'll come back to that in a moment, because once they're unsold, you need to actually put in place certain things, because otherwise the creditors can no longer get access to those assets. So underpinning all of this is the vesting effect of the legislative scheme. And as I was saying, the bankruptcy trustee has a number of significant powers under the Bankruptcy Act. Under Section 58, subsection 1, the property of the bankrupt, as I'm sure everybody knows, vests immediately, forthwith, in the bankruptcy trustee as at the date of bankruptcy. And then the description of the property that vests in the bankruptcy trustee, that's all defined within Section 116. So, of course, under the creditor's report, it may well say that the debtor, the bankrupt, holds very little, but creditors' reports don't always tell the whole story, and there's often a lot of other assets elsewhere, as you will discover once you've done the ASIC searches and then the property searches. The ASIC searches to find out how many companies the debtor owns, and everything that wasn't actually disclosed by the debtor to the bankruptcy trustee. So those two provisions, and you've got copies of them there, they act together to give the bankruptcy trustee vesting power. And once you commence your proceedings, you will have commenced against the bankrupt, and each of the individuals or companies that the bankrupt has dissipated assets to. So, for instance, the bankrupt may have dissipated all of the shares in each of his or her 4 companies to his nephew, his niece, his best friend at work, and 4 other people. You'd need to join all of those 4 people. You'd need to join the companies, and you'd need to join everyone to whom the assets owned by the companies had also you need to join the purchases, the purported purchases of the assets owned by the companies. You could have 8 or 9 respondents. as parties, as respondents to your federal court proceedings or more. And so once you commence your proceedings, then the arguments that the debtor and all of the Confederate rogues, associates, everyone who's joined in the scheme, if you like, the arguments that can be put against you are often that the assets were never directly held by the debtor. So the debtor may say, well, they were not my assets, they were all owned by the companies. But that isn't such a difficult argument to overcome, as you'll see, because the bankruptcy trustee simply stands in the shoes of the debtor and owns, at the end of the proceedings, the bankruptcy trustee becomes the shareholder of all of the shares in all of the companies. But a bigger argument that you may need to overcome is where trusts have been established. So, for instance, discretionary trusts have been set up, and those discretionary trusts have been established in respect of each of the properties, and it is purported that the discretionary trusts hold each of the properties. So each of the properties is a trust asset. So then, even though, as you can see, the bankruptcy trustee stands in the shoes of the bankrupt, there are cases that say that trust assets, so there's a very famous case, we'll come to it in a moment, Dwyer and Ross, you can see that that is authority for Section 116, does not include trust property. So if it is legitimately trust property, then, and it's held on trust, then it's not property that Section 116 will capture. So that doesn't vest in the bankruptcy trustee. However, if you're bringing a claim under Section 37A, so these are the arguments that may be put against you by the by the debtor. As I said, that the assets are not held directly by the debtor. They are held on trust, or they're held by companies, and by companies on trust. Therefore, the debtor has no interest in the assets because the assets are trust property and are not property divisible among creditors under Section 116. And also in trust deeds, there's a standard term that provides that once the beneficiary becomes a bankrupt, the beneficiary is an excluded person and therefore no longer a beneficiary. And so therefore that would again evade creditors. When those arguments are put, so the response to the assertion that assets were trust property, that issue was considered in a decision that's in the article that you've got before you, Royal and Alali. So the court simply said under Section 37A, 37A is not concerned with that. 37A is concerned with the dissipation of property. So once the trust property is dissipated, for instance, for $1, so at substantial undervalue, it's dissipated and the proceeds somehow find their way back to the bankrupt, that's still money that finds its way back to the bankrupt, and that is caught by Section 116. That vests with the bankruptcy trustee. And the court said Dwyer and Ross is no answer to that. The fact that it's trust property is simply no answer to when it's dissipated, when it's moved around at undervalue for the purpose of evading creditors. And in relation to the argument by the debtor in that case that the deeds, each of the trust deeds, contained a term that said as soon as the beneficiary is the debtor beneficiary is bankrupt, he is no longer a beneficiary, he's an excluded person. Well, Section 302 capital B of the Bankruptcy Act plainly says on its face that any term of a trust deed that cancels or reduces the interest of a beneficiary upon the beneficiary becoming bankrupt is void. And that so in Royal and Alali, the finding was there that section of the Bankruptcy Act clearly applies to those terms that say a beneficiary is an excluded person, is no longer a beneficiary as soon as they're a bankrupt, because that simply acts to cancel or reduce the interest of a beneficiary. And its purpose, of course, is to evade creditors, and the court could see that. So, and that section 302 capital B of the Bankruptcy Act hadn't been considered until that point in time, so it's a helpful section to overcome what is a reasonably standard term of a trust deed if that term then gets used to evade creditors. And finally, it must be the case that if a debtor asserts that all of these properties, prima facie worth substantial value, are in fact trust property and therefore out of reach of creditors, prima facie, well, it has to be established that they are in fact trust property. So in the case that, in Royal and Lally, for instance, in obtaining freezing orders in relation to the assets in that case, many years ago, Justice Foster said to the respondents, because they said, well, this is all trust property, so it's simply out of reach of the creditors. And Justice Foster said, fine, if it is trust property, you will need to put all of the relevant evidence, put all of the records, all of the books, everything that demonstrates that it is trust property. I assume you will do that. You put it all before the court. You'll annex it to your affidavits. So His Honour said that in 2014, and then the case came on for hearing in 2016, and they continued to maintain the argument that the properties were trust property. And so we ran the arguments that Section 37, all of the arguments you just saw a moment ago, that if it is trust property, well, that doesn't matter because they've still moved all the properties around anyway and dissipated them at not arm's length conveyances for undervalue at $1. But more than that, after cross-examination, after the hearing, after everything and closing submissions, it was just apparent that there was no evidence that Justice Foster had foreshadowed many years before. There was simply no evidence adduced by the respondents to prove that these were trust properties. They'd tendered all of the deeds, the trust deeds. The deeds clearly said, this property situated here, this is the subject of this trust. And all of the deeds were in evidence, and they'd all of the properties had been purchased by the bankrupt many years before as trust property under the Duties Act. So he'd paid a $50 duty. So when you buy trust property, the duty is substantially reduced. You only pay $50 under Section 97, subsection 3 of the Duties Act. It's a very reduced amount of duty that you pay. And he said, and all of the evidence of that was annexed to all of the affidavits as well. And the basis of the argument was, well, we only paid that amount of stamp duty, so therefore they must be trust properties. And of course, Her Honour Justice Davies simply said, well, no, that just means you've defrauded the OSR as well as all of the creditors. So they were never trust properties. There was simply not sufficient evidence. Under cross-examination, of course, it was demonstrated that the properties, rather than being actually legitimate trust properties, they were used as though they were the property of the people who held them, as though they were treated. They were used to underpin many other purchases. They were used as security left, right and centre for many other transactions, and they were treated as though they were owned by each of the purchasers who had purported to purchase these properties for $1. So, and none of it was held on trust, even when it was initially trust property held by the companies. And that was really central to the argument. Now, this all went on appeal to the full federal court and then to the High Court, but that argument, none of that was ever appealed. Now, that, of course, means it's all a single judge decision, but it has been applied. Much of this has been applied since then. And then other arguments that the debtor can put against you or against the creditors is that, well, the assets were all substantially encumbered. Underwater was the word that was used all the way through the case that we ran. The assets were underwater. They were so encumbered that they were worthless almost. So therefore, there was no diminution of property available to the creditors. There was pretty much nothing divisible between the creditors under Section 116. So, and there could have been no intent to defraud because moving the properties around meant nothing, because there was simply no value left in them. Now, that is an absurd argument. They ran with it for a very long time. If it was worth nothing, why were they moved around? Why were the properties continued to be dissipated amongst themselves for $1? And then one argument also was that at the point of when the property was purchased from an external innocent third party, when it was initially purchased by one of the companies and then purported to be held on trust, it was then transferred away to a rogue colleague for $1 so quickly that the purchase contract had not yet completed. And so the argument was there were no property rights there. There was simply no proprietary rights. All that there was this trail of contractual entitlements, and that wasn't property. And so therefore there couldn't have been an alienation of property under Section 37A. Now this argument went to the full federal court. And in fact, both of those arguments went to the full federal court. And you can imagine the short shrift they got there, but we'll look at that in a moment. So this is the full federal court decision. And there were several full federal court decisions that came down in May or two that came down almost within a week or two of each other last year. The other one didn't consider this particular issue, but it considered Section 37A and very similar issues. So of course, the questions of value of the assets are irrelevant. So this was said at first instance. So Justice Davies found all of these things, and then the full court unanimously simply pretty much adopted everything that she found on almost every single point. So you've just got a stream of 4 federal court judges saying almost exactly the same thing, and often they just picked up her judgment verbatim and put it in their judgment, because the arguments run on appeal by the appellants were almost identical to the arguments that they'd run in the court below. So questions of value of the assets are irrelevant. Where a property just purchased and still under a partially completed contract is dissipated, what is relevant is that the plain intent was that the contract would complete and the property would be alienated into fraud creditors. So it's just not relevant that it just went so quickly through. You purchased it there for $5 million, transferred it to your friend or nephew for $1. It doesn't matter that this contract here was just not even complete then. All that matters was the intent for Section 37A, plus the definition of property under Section 7 of the Conveyancing Act is so broad that it captures even the alienation of property subject to a partially completed contract, an uncompleted contract. So a lot of the argument was about the fact that one of these properties of reasonably significant value was subject to an uncompleted contract at the time it was transferred away, whisked off for $1. And now this issue was also considered by the full court, and it's been considered reasonably recently in Western and Sana. So it was considered by the full court in the Royal and Alali proceedings, and then it became Zrecker and Royal. But so this is the case with every single dissipation of an asset. So as soon as the debtor starts dissipating assets at undervalue for $1 to his circle of trusted rogues, then it is very important, well, number one, it's very important to know that it's happening. It's very important to keep doing the property searches and to watch and see when they're being dissipated and where they're going. Firstly, so that you know what you're chasing, but also because the second it hits the deponee, then it's a prima facie assumption by the court that it's a clean, legitimate transfer. And the bankruptcy trustee has to defease the transfer, has to stake his interest, if you like, in it, or her interest in it, but has to stake the claim. And it has to be done very quickly, because once it's on-sold to a third party from the deponee who got it for $1 and on-sold for $7 million, then that is laundered in a sense. It becomes, you can't then, or you may be able to through tracing orders, all of which are expensive and a lot more time consuming. You may be able to trace that, but short of that, the prima facie assumption is once it's been on-sold to a third party at arm's length, a commercial arm's length transaction, at value, not at undervalue, it's pretty much gone to creditors unless you can get tracing orders, things like that. So it's really important to act pretty quickly. As soon as the property searches show that it's been transferred to my niece for $1, then the bankruptcy trustee has to immediately write, which is what we did. The bankruptcy trustee wrote to each of the circle of rogues and of course to the bankrupt, and said, we're calling for delivery up or revesting of the property that was just transferred 2 weeks ago or 1 week ago or yesterday for $1. And we're going to commence proceedings. But the safest way of doing it is simply to put on a statement of claim, just commence proceedings, put on your application and your statement of claim in the federal court. Now, of course, there's risks with that as well, of commencing as quickly as you can, but that defeases the title. And then the donee may deal with the until then, the donee may deal with the property as owner, and that's a very old. That's Brady and Stapleton, and that's something that you just have to make sure you keep an eye on. And that, in our case, that argument was not run. The other side didn't even touch that at first instance. Then they got a brand new senior counsel in on appeal, and I think about a week before the full federal court hearing, he suddenly came into the hearing and he put on some submissions weeks after the timetable had closed, and he said, oh, and by the way, we forgot this. And it was one of the properties had been unsold, nobody knew about it, and so there was no evidence, there was nothing, and we just said, we said, well, it wasn't run at first instance, you can't let it in, plus we did defease it and all this kind of stuff, but that was the one thing out of 10 years of about 20 cases, including about 10 interlocutory cases, that they were successful on. But the point, it actually didn't harm the ultimate outcome because all the money had already been paid into court. And then we were able to get court orders that money get directed to other things anyway, because of course they weren't going to pay anything. None of the circle of rogues would pay anything unless the money was in court. So we'll come to that in a moment. But that's a really important thing to avoid. We'll keep an eye on. So section 37A, subsection 3, provides a statutory defence, and that the rogues may rely upon that. Section 121, subsection 4, also provides a similar defence. It is helpful to commence proceedings in the alternative under both of the provisions. Section 37A contains a lot fewer elements. It's simply a lot easier to prove, and of course, as Lucas was saying, you can commence against a corporate entity because you don't have to be commencing against a bankrupt. So you can join everyone. If you've got proceedings under Section 37A, you can join everyone and everything that you need to join, and you don't need to worry about it. Whereas under Section 121, subsection 4, you can only commence it, you can only proceed against the bankrupt. And then the onus is on the party relying on the defence under Section 37A, subsection 3, to make it out. That sounds like a fairly straightforward thing. There were two major streams of cases all the way up until the full court decision last year in Zrecker and Royal. That's now decided at the full court level. The onus is on the party relying on the defence, and an absence of good faith can be shown by the transferee's knowledge of the insolvency and that the transaction prejudiced other creditors. So, of course, all of that can come out in cross-examination. So you just cross-examine on the emails, what are you doing now? How are we going? What are you doing to make sure the royals don't get their money? All of that kind of thing. Now, people will email that kind of thing to each other. They'll text it to each other. It gets into evidence, or it just comes out in cross-examination. So the transferee's knowledge of the insolvency, have they bankrupted you yet? All of that kind of thing. There's emails, and so it's just all of it can come out in cross-examination and can demonstrate an absence of good faith because of the knowledge of the insolvency, and that the transaction prejudiced other creditors. It's clear that if you have a knowledge that you're moving something so that someone else doesn't get it, that defence is going to simply disappear. So that fell away for each of the rogues in that series of cases. Even aside from the arguments that you can put back, that you can use to resist the arguments that the debtor is going to run, the debtor and each of the co-rogues, if you like, are going to run against you, there are a large number now of very helpful findings at the appellate level of the interpretation of Section 37A and just how broad it is. So it's beneficial legislation, so it's interpreted very broadly in favour of creditors, because the courts are trying to get the creditors their money back, essentially, if it can be accessed. So last year, the other case that was decided by the full court in May last year is Israel Discount Bank Limited and ACN. Between that case and Zureka and Royal, the full court has two different full courts have confirmed a series of really helpful principles. So a broad approach is to be adopted as to what constitutes an alienation of property. And the main purpose, that's the words used under section 121, but it means the intent, essentially. The main purpose may be proved directly or it may be inferred, including from the objective circumstances. So the objective circumstances include how desperate the bankrupt's financial situation was just before he was bankrupted, and then how he was moving properties around frantically to try and patch things up and keep it all together. And all of those transactions, all of that is objective evidence, and all of the cross-examination that flows from that is objective evidence from which the main purpose or the intent to defraud can be inferred. And there's a number of cases that have dealt with that, and all of those cases are summarised in Zureka and Royal. And then, of course, a subtraction of assets, which would otherwise be available to meet the claims of creditors. So if some of the assets are gone, well, that all by itself is material from which an inference of the intent to defraud those creditors might be drawn. So the inference of intent to defraud can be readily available from just the movement of the properties at undervalue. And then if the property is transferred at an undervalue or is given away, that is a fact relevant to the intent to be attributed to the disposer in disposing of the property. There's only so many reasons you'd give 5 properties owned by 4 different companies to 8 different people for $1 each. And so at around the time that you're bankrupted, with creditors banging your door down. So these are things that the court is just simply going to look at the big picture and can draw inferences in that respect. And then whether there is an intent to defraud creditors involves a question of fact concerning actual knowledge, but it's not necessary to prove a desire to cheat or swindle those who are prejudiced. So there needs to be actual knowledge of all of these deponees and the bankrupt, but it's not necessary to prove that they're all out to cheat and swindle. And it's not necessary. It is necessary only to prove an intention to hinder, delay, or defeat creditors, and that's from Marcolongo and Chen, and that was the High Court in 2011, and that helped tremendously back then, and that was just before we commenced proceedings against the rogue and all of the co-rogues in these proceedings, or just when we got the judgment debt and then continued to pursue it, but. Really, all you need to be able to show is an intention to hinder the creditors, and that is not nearly so high a bar, and so that's been the case since the High Court said that in Marcolongo and Chen. It's not necessary to show that the debtor wanted the creditors to suffer a loss, or that was the purpose, and it's not necessary to show that the intent to defraud the creditors was the sole or the predominant reason. So if the debtor's transferring things around to try and pay off this, that and the other and underpin other transactions, well, those are reasons for the transfers as well, but it doesn't matter that those are the reasons as well. What matters is that really there was also a reason that the creditors are being defrauded, and then Section 37A should receive a liberal construction in effecting the purpose of suppressing fraud. And then at the end of the principal decision, the really important part is the recovery orders, and that may be something that can be dealt with as a part of the principal decision if it's not too complex. If you've got less than, say, 8 or 9 respondents, and you can get your recovery orders within the restraints of the principal decision, then you can do that. But otherwise, you may need another day of hearing or half a day of hearing to get the recovery orders because they're reasonably complex. They're not that hard to obtain. They're just, you've got to get, first of all, you just need to get the declarations that the transfers are all voidable. And then you need orders giving effect to the principal decision to enable recovery, which includes the orders vesting the shares in the bankruptcy trustee and the orders winding up the companies, or alternatively leave to proceed against the companies who are by this stage in liquidation. So many of the companies you've proceeded against may be now in liquidation. You need orders to proceed against them at the end to get the orders that you need. And you need the orders that the proceeds of sale be paid into court. And you need priority orders under Section 109, subsection 10 of the Bankruptcy Act. And the priority orders, you just put those in the pleadings at the beginning, and at the end, you make your argument to get those. By this stage, there's almost nothing that the opponents can say to resist orders such as priority orders. Priority orders give your creditors priority over all of the other creditors because it was your creditors who took the risk in running the litigation. Usually your creditors will have indemnified the bankruptcy trustee with an amount of money, pay that into trust. Bankruptcy trustee is therefore indemnified in respect of the proceedings, and that is the evidence that your creditors took the risk and therefore get the priority orders over and above other creditors. It doesn't differentiate between secured creditors and unsecured creditors. That's incredibly important. So all of these things you can do. You do that at the outset, but then at the end, that's when you just get the court to make all the orders. And at the end, much of it won't be opposed, some of it will be. And you can see here, once again, Section 58 and 116, that's when all of that comes into effect. So the bankruptcy trustee is entitled to be the registered holder of the shares previously held by the bankrupt under Section 58. And where the shares had been dissipated by the bankruptcy trustee has standing to correct the share register under Section 175 of the Corporations Act and reverse all of those transfers, reverse the transfers of shares from each of the circle of rogues back to the bankrupt. The second it hits the bankrupt, it all vests immediately in the bankruptcy trustee. The bankruptcy trustee, as sole shareholder of all the companies and then sole office holder, controls everything, all the assets that have also been reversed by order of the court back into those companies. And then the bankruptcy trustee liquidates all of it or has the proceeds of sale paid into court. And then, of course, the bankruptcy trustee has standing to apply for the winding up of the companies under the Corporations Act. And all of this, there are not very many decisions of the federal court where this, or any court, there's just not many decisions where all of this has played out because it resolves before this often. But if you have debtors, and there's cases throughout the federal court, Coshett and Coshett is another one, Coshett and Burke, Coshett and Prentice, they just go for years and years with circles of rogues just refusing to give in and just fighting and appealing. But those two cases there, it sets out all of the orders and declarations that you need, and then there's the argument as to why the creditors get them. And then, of course, when seeking orders to wind up the debtor's company, fraud or misconduct are significant factors relevant to the exercise of the court's discretion to wind up on the just and equitable ground. So you get the orders just to wind up. At the end of all of this, if your opponents appeal to the full federal court, or appeal, if you're in the Supreme Court, to the Court of Appeal, then you need to have asked, when you get your costs orders, you need to get your costs orders on a fixed sum basis, payable within a certain period of time, and jointly and severally, because by this stage, many of the rogues who are respondents, they've bankrupted themselves to avoid all of this. But there's usually one or two people left standing, and you need to get joint and several costs orders. And this decision adopted so the full court in Zrecker and Royal simply picked up Her Honour's reasoning in the cost decision, plonked it down in theirs, and they said, we just adopt all of that. So then you've got 4 federal court judges saying in a row, saying exactly why you get jointly and severally payable costs orders. So that the rogue left standing, who is very often the rogue most interested in everything, and that's why he didn't bankrupt himself, and that means he's got all the money somewhere. And remember, all of this was funded by someone somewhere, or many someones somewhere. It's bankrupt. Where did the money come from? And of course, the court knows that. And but it comes from somewhere. The money is somewhere, and there's always money. So you've got to get the costs orders paid into court. And if they won't, well, paid to you preferably, but of course once they appeal, they're going to say no, everything's, they're going to try and get a stay on everything. But you can seek a stay of the appeal, so you simply file an application to seek a stay of the appeal until all the costs are paid into court, and all of the awards of money at first instance, it all has to get paid into court before they're allowed to appeal, because of course, or continue with their appeal, because they're in breach of all of these orders now. So that's really important, because otherwise you'll get to the end of it and there'll be no money in court. And security for costs on appeal. Remember, there's different considerations for security for costs on appeal. And one of the most important issues is that, it was the last dot point, but it's one of the most important. While impecuniosity and insolvency at first instance don't mandate an order for security, that doesn't necessarily apply in an appeal where the appellant has had the benefit of a decision of a court at first instance. So the courts, there's a lot of decisions that have said the appellant has had his day in court. He's already run his case. Now it's different. Now, if he wants to appeal that, and he says he's impecunious or insolvent, or the evidence demonstrates, he's not saying it, but the evidence demonstrates it, then there must be security for costs paid into court. And of course, there may be no evidence whatsoever as to any of the appellant's financial status, because none of them have been silly enough to comply with any orders to put on an affidavit of assets and liabilities. The affidavit, those are further breaches of court orders. They just refuse to put them on, because of course they know that once they're in the witness box and cross-examined on those affidavits of assets and liabilities, it may become apparent that there's money all over the place. So they won't put those on, and from that the inference can be drawn that there's no evidence as to their financial status. So the security for cost orders need to be made, because we don't know that we're going to get paid. So that is usually a way of getting security on appeal. And of course, the debtor contributed to the impecuniosity of it says the plaintiff, but by this stage it's the respondent in the appeal. The appellant is proceeding for the benefit of some other party. Well, by this stage, the bankrupt is not the appellant, because a bankrupt doesn't have the right to appeal. All of the co-rogues are the appellants. So the co-rogues, the inference can be drawn that they're all proceeding for the benefit of some other party, namely the bankrupt. Another reason to award, to give orders for security. And of course, reason to believe that the appellant has divested assets with the intention of avoiding the proceedings. Well, the whole case has been about the fact that they've all divested these assets for the purpose of evading creditors, which is the purpose of the proceedings. So these are all really relevant facts and can be used to get security on appeal and get that paid into court. But of course, the security doesn't usually covers very little, but it is something. So, in conclusion, and I recognise we're out of time, determine the assets and shares owned by the debtor early with all of the searches that you need to do, and the debtor's companies. So do the property searches and the asset company searches, and determine the encumbrances as early as possible on the assets by production of documents to try and figure out, sometimes it may not be worth it. It is the case that the value of the property doesn't matter, so you could still win, but maybe it's so encumbered that it's just, all of the assets just aren't worth it. But there's usually money somewhere. Rember, creditors' reports don't tell the whole story, don't always tell the whole story. Move quickly to prevent a property dissipated by a debtor being on-sold by having the bankruptcy trustee. Well, you won't prevent it from being on-sold. You can get freezing orders to try and do that, but you won't prevent it from being on-sold in the absence of, say, freezing orders. But once it is, you want to prevent it essentially from moving out of reach of the creditors by getting the bankruptcy trustee to stake his claim, to defease it essentially, call for delivery up, revesting of the property, or just commence proceedings. Again, for all of the costs orders along the way that get breached, the freezing orders that get breached, all of the breach of orders, it's prima facie contempt. That can be used as well in argument without having to prove it. In terms of actually bringing contempt proceedings, you can consider that it's expensive, it's time consuming, the creditors have to pay for it, and it doesn't put money in the pockets of the creditors. So it doesn't necessarily get the creditors anywhere, and on appeal get first instance costs and security paid into court. So, and those are the central messages. And if there are any questions for Lucas, for me, please feel free to ask. Yes.
In the Conveyancing Act action talks about the transaction being voidable, and the Bankruptcy Act action says it's void. Is there any practical difference?
No, well, there hasn't been in the cases, that I've been in and not in the cases I've looked at, because at the end you just get the court to make the declarations that it's void. So, and then all the transfers back, it won't have any implications, because the declarations are just the preliminary aspect of it, and then you get all the orders transferring everything back again, and that's the practical effect.
And if you've got a choice between Bankruptcy Act and the Conveyancing Act, is there any circumstances in which you would choose to let go as a Bankruptcy Act over the Conveyancing Act?
Only if there are no companies involved, because you can't join them under the Bankruptcy Act, because Section 121 is only against a bankrupt.
But the Conveyancing Act action is easier, isn't it?
Yeah, yes.
So if you have a choice,
You'd always go with a Section 37A. Well, in my experience, there's no real reason. There's less elements to prove. It's broader. It's more flexible, and you can you can join all of the corporate entities that you need to. You can join the whole circle of rogues. You don't need to worry about who's bankrupt and who's not. And yeah, I can't see a reason to go under Section 121. But you could plead them in the alternative, which is what we did. We just pleaded them in the alternative.
Is it easier for a trustee to use the 139Z provision?
Yes, they can do that, but they've got to then have the money, and it's often the creditors are the ones driving it. So the creditors under Section 37A. We did look at that, but the bankruptcy trustee by themselves aren't really going to take that many steps unless it's kind of litigation driven by the creditors, by some. Yes. Yes, exactly. So that there's plenty of other powers in the Bankruptcy Act that a bankruptcy trustee can use, such as powers of examination. If there's time to do that, and you think that examining the debtor or the bankrupt might actually get some information from him, but sometimes just commencing proceedings is the quickest way to move things forward, especially if properties have been sold. But yes, if there's if in the circumstances of your case, if there's anything that can be done more cost effectively, remembering the powers under the Bankruptcy Act, there's many and varied powers, and if you think that an examination will, or Section 139Z, anything could give rise to a result more quickly and cheaply, then yes, in our cases, in all the cases I've looked at, it hasn't been. Yes, it's litigation that is used. That's simply, I think it just recovers the assets more quickly, and it's funded by the creditors. Otherwise, the bankruptcy trustee has to run it. Yes.
Just a general question about Section 302 concerning trust property. Does that differentiate between having a fixed interest under a unit trust or an interest in a discretionary trust?
Section 302, capital B.
I think so. I think you referred it to one of the slides.
Yeah.
There was an argument about
whether there was a term.
Interest in the property which was held under discretionary trusts.
No. Section. I'll just go back to it. Section 302B in the Bankruptcy Act says any term of a trust deed, and it doesn't differentiate between unit trusts or discretionary trusts. Any term of a trust deed that cancels or reduces the interest of a beneficiary upon the beneficiary becoming bankrupt is void. So it's just
a general interest in that trust.
Yes, exactly. That's right. If the beneficiary's interest in the trust has been reduced, that's only subsection A of section 302 capital B. There's also subsection A or B, but there's another subsection as well. But it doesn't differentiate between any kinds of trusts.
No, because I was just thinking, I've seen a few trust deeds where there is that general argument.
Yes.
Sorry, that clause.
Yes.
And the argument becomes that I've seen is that I don't really have that fixed interest. It's up to the discretion of the trustee whether or not I get certain property. That kind of general argument, but
Well, that's true, but
Yeah.
then it would have to be interpreted if there's a possibility that it could be reduced,
yeah.
that the interest could be reduced. But it's considered in Royal and Lally at those paragraphs, and that was, it's a reasonably fulsome, I should say, fulsome kind of consideration of it. But I think it would be difficult for someone to rely upon it now. To avoid creditors, that means. Are there any other questions? No? Thank you so much, everybody, for coming. I know it's very early in the morning. Thank you very much for your time. It's close to the end of the CPD season, so thank you very much.